Den. Hallå, 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 hallå. Välkomna. Hörs det något? Hallå, testar mikrofonen. Hörs det något? Nu så. Hörs det lite. Mm. Okay, it's past 3 o'clock, so very welcome to this legal crash course for startup hosted by me, Johan Ragnar, from the law firm Synch, and very welcome also to you watching this online. So even though I guess most of the people here speak Swedish, I'll have it in English in order to reach a broader audience. So this is Synch. It's the main office in Stockholm. We are present in Stockholm and here in Helsingborg so far. This is me, just to let you know me a little bit closer. I like long distance running. I'm very much into FinTech. That's my specialty within law. I play the piano since I was 6 years old. That is not about law. That's about my addiction to auction sites. That's what I do in my spare time, to look at beautiful old things. It's my family in the middle. It's Maria, my wife. She's a midwife. We have 3 sons that are 10, 8, and 4. And this is Nils, is the oldest one. This muscle package is Carl. And then we have the little clown, Folke, the last one. This is our dog that sadly passed away last summer, but I'm still dreaming of a new dog. Well, and just some very short introduction to Synch. We are a business-oriented law firm. We have innovation and tech at our heart. So it suits us very well to be located here in the Hedge House in Prisma. We were founded about 8 years ago with a mission to make it better legally wise for tech and innovation companies, and have succeeded very well in that. I mean, a lot of companies right now, they have some element of tech and innovation. So it's been proven to be really good. Here are my friends. Actually, there are missing a couple here. I think 7 people, which were recruited in April and May. So we're growing constantly, also because of the demand for our services. So we have our 4 founders, and then the rest of us. We were also merged with another law firm last January. So we got 12 new colleagues, and that had turned out completely without friction. So it's been a great journey to have them join us. These are our values: transparency in everything we do, both clients and internally. Curiosity, find out what does your client do, what is going on around in our surrounding world. Read newspapers, read online, keep yourself updated within your legal fields. My favorite is friendly. We're kind of softer than most law firms without being not providing very sharp advice and so on. That's our main task. And then also harmony, to stay in harmony with our surroundings. So value-driven organization, and quite soft when it comes to these internal values, at least. Mygon is our legal tech project, which used to be in-house. Then we wanted this to grow, and only lawyers can own shares in a law firm. So in order to have external capital, we decided to chop this off to a separate company. It's going really well. We have AI-based agreements review. So you can just run, for example, a personal data policy within Megon's system, and a minute or so later, you have a complete review of the document through the use of AI. We have trained that. That goes for NDAs as well, end user license agreement, and we're now basically every agreement which is basically standardized, because you need to have some sort of standardization in order to compare the document you're viewing with that. So that's short introduction to Synch. Of course, I can talk about that forever, but that's not the subject of the day. So we're going through a number of fields which are good to know when you're a startup or a scale-up, coming a bit longer. And we're going to start with financing. And financing is basically a lot of things. It's a lot about different kinds of money. And here we have 4 kinds of money. We have cash. You need to pay salaries, your rent, your R&D, suppliers, and so on. All the bills that come every month. Then you have your other assets. That could be marketing that you earned, values that have during the times built up in the company. You have consultancy hours which need to be paid as well, and other assets which are useful in your company or your venture. Now on the liability side, you have equity that comes on the price of dilution, and dilution is when you expand your ownership sphere, you as a founder become less influent in your company because they want to have influence as well. And because of that, your influence decreases. But equity builds solidity and capital coverage because it's a protected kind of money that stays and sits within the company. And then you have debt. You go to the bank and take a loan, and the price for that is to pay interest. And also the scary thing that if you are not able to pay your bills, the bank would most probably demand that back, and eventually you could, if things comes to worst, go bankrupt. This helps liquidity, but it's best used for investments rather than paying your running costs. So say you need a new machine, you need new computers, then it's better to use the debt. And here are some key concerns when it comes to money. For the cost, it's the, as I previously mentioned, the interest and the dilution. When it comes to control, you have the influence over the business, also related to dilution. You can also have a founder lock-in, meaning that you can't leave the company when you wish. In the shareholder agreement, perhaps those putting in a lot of money into the company, they don't want the 2 founders to leave, because then the most valuable human assets will be gone, and the passion is gone, and the company will eventually die. They can also have an influence over exit, say that you need to have this valuation before we do an exit to put you on the stock market or sell you to an industrial party. Through the acquisition of capital also comes competence. You can ally with strategic partners, so you can sort of buy them in order to grow your company. The same goes for access to competence. Perhaps, I mean, it's very modern now to have an advisory board, and they are not really a formal board of directors. They're not registered anywhere, but they can still contribute a lot to the company, and they can also get share options in order to to increase their effort in the company. But you also need to take into account the complexity of gaining money. It could be really complicated, and that's where we lawyers come in mostly, to draft the agreements, especially the shareholders agreement, the investment agreement, and so on, and the share purchase agreement if shares are to be purchased, or perhaps an option agreement, qualified options. We'll get into that later, but we do those basically every week. This is the timeline. You have the preparations where you first scout for different investors. You also do an internal diligence and cleanup of your company in order to present this to be really nice and tidy for the investors. We have a product there which is standardized that Synch can help you with. And the documentation is the pitch deck. You've seen them all, the PowerPoint, 14 pages, and they follow a certain pattern. You can also have a teaser without saying too much, just wake the interest of the investor. An information memorandum, it's a bit larger than the pitch deck. And then you can also voluntarily have an NDA if you're about to disclose secrets and so on, because you don't want anyone to know of these facts. Then you start the term sheet negotiations. They can be quite lengthy. This is sort of a pre-stage to what's to come. You can also do that with a lot of different parties. Then the due diligence is performed. This is a stage where the future investors look more deeply into the company. Prior to that, you probably need to sign the term sheet and absolutely the NDA, because now you let them into your company. And if you don't have an NDA, they can go tell everyone about it, or they can start their own business. Or perhaps it's a competitor that is about to buy you, and they can gain your knowledge through the due diligence. Then you start drafting the shareholders agreement, investment agreement, and perhaps also employment agreement if founders or anyone else who's not employed currently in the company are about to be. Also to stick them closer to the company. Then you have the final docs. You sign those, the shares are issued, the money comes into the company, and you're done. So these different stages are the preliminary stages. Then you have the non-exclusive. You negotiate with a lot of different parties. At the third stage, it comes exclusive. You only have one party that you're negotiating with, the one that you felt more comfortable with, or the one who contributes with the most money or have the best competence. And then when you sign the documents, that's when they become legally binding. And that's when you drink champagne and celebrate. So you have the term sheet, and these are some key terms that usually are in the term sheet. So think of these within the pink there as headlines in the term sheet. The valuation of the company, that's very interesting for founders at least. You want it to be as valuable as possible. The lock-in, I mentioned that before. You need to lock in certain individuals, certain competence for a period of time in order to keep developing the company. And there's also a risk of giving away too much of your company. Say that you're two founders having 50% each, then an investor comes in, you give away 30% of the company. Then you're down to 70%, 35% each. Then another investor comes in, and suddenly you sit there with 8% each. So what's in it for me anymore? I lost all my interest. This is not fun anymore. I'm basically employed. So from having all effort into the company coming back to you, you suddenly have nothing or almost nothing. So think of that. The non-compete, if you leave the company for some reason, you're not allowed to go to a similar company for a certain period of time. It's usually between 6 months to 24 months. So you need to do something else. And that's because you're not supposed to just jump off the company and start something similar and just kill your old company. That goes for the transferability of shares as well. You want to keep the shares within a certain circle of owners. So you have very common regulation within the shareholders agreement, preemption rights. So so if you want to sell, or if you do sell, the existing owners have the right to buy them back. You also need to ask all the existing owners, am I allowed to sell to this external party? No, you're not. They're saying you need to sell it to us first. That's also because you don't want any person to be a shareholder. And this goes, of course, for private companies. Publicly listed companies, they are traded, all the time. I'm not going to go through all of these because the drag and tag are pretty complicated, but basically that means if it comes an offer for one person, the other ones are allowed to tag along. So, and this is to enable the whole company to be sold instead of just tiny bits and pieces here and there. Board representation, most investors want to sit on the board because then they get more influence over the company, and they also want to look after their money, so to say. Now, we're moving on to intellectual property. This picture is taken from Patent- and Registreringsverket. And we have 4 different kinds of intellectual property here. We have the trademark for this shoe called Pro Solution. That needs to be unique. And you can't really start a shoe brand called Nike anymore, or Adidas or Puma, because that's already taken. And our Pro Solution, such stupid name, but yeah, that's taken. You have the design. That's the whole shoe as a whole, which could be protected. A car could also be protected through its design. These tables here, you're not allowed to copy. And speaking of that, IKEA is a master of putting the furniture just as close to an existing one in order to make it look like 10,000 kronor furniture, which they charge like 1,500 for. They're very good at that. There was a big trial here in Helsingborg a couple of years ago because IKEA had launched a flashlight which was very similar to the Maglite, the military standard Maglite, really good one. And I think IKEA lost after many years in trial because of that, but they kept on fighting. We're going to sell this. Then you have the patent that needs to have a certain uppfinnarnivå in Swedish, so a certain degree of innovation. This could be a certain sole. So going back to Nike, Nike Air, that's probably patented. And certain things in this computer is as well. A coffee maker, perhaps, if it's unique enough. And speaking about coffee and unique, some trademarks have been diluted because the society have adopted its name as something that applies to all kinds of that thing. Thermos, for example, is a brand. Vespa was an Italian brand. You call all motorcycles with this thing on the front for a Vespa. So that's quite interesting. And then it loses its value as a trademark. No, it's Vespa's, the original one, still has its value, but in society it's diluted. No one cares about if this is a Vespa, or Yamaha, or Honda, or whatever. But it's called a Vespa, and I mean thermos, what else would you call it? Container for hot drinks. No one says that. No. And copyright is more about text and symbols and such. And same thing there, it needs to be identifiable and unique. And did you know this? IP, intellectual property, represents today nearly 70% of corporate assets at the stock exchange. That wasn't the case, 40 years ago. It was steel and forest and cars, perhaps. But now, when we have this IPR society, so to say, an Apple iPhone, look at Apple. It's worth billions and billions. And it's basically built on only IPR. The looks of an iPhone, zoom and stuff, all kinds of patents inside this little thing. And software companies, look at Tesla. There must be hundreds, perhaps thousands of patents for that. Speaking of patents, it's quite complicated to apply for one. You usually need both legal and engineering competence, but I'm sure you know there are certain patent bureaus that help out with this. So here are a number of different IPR. You have the copyright, as I mentioned before. You have the trademarks, design rights. Usually you talk about code. Could that be patented? Not very much. Computer code. So, but it could be designed, or it could be a copyright, such as a novel. If someone writes a book, I can't take that text, just copy it and put my name on it and issue it on the market, because that would be an infringement against copyright. However, if I put that book in one of those text-generating AI-based software which are available on the market, I don't know if you've tested those, but you can put text in it, and it rearranges the text in different words and such. However, the content is the same. That's quite interesting. And speaking of that, we also have AI. This is off topic, but books written completely from scratch by AI. It's pretty cool. Yes. Yeah. Right. And most sports articles today are actually written by AI, especially those who are just statistics. HIF lost against AIK with 0-1. I don't even follow soccer. I just see the helicopter in the air and get angry that my taxman is flying around up there. Really angry, actually. So you can also protect it through contracts. Two people, perhaps they have, or I'm working at Synch and I have this great idea that I come up with that Synch can use, but it's my invention. Then it's actually regulated in law that it's mine, unless I transfer it to Synch. And then we need to write an agreement in order to, they pay me, that could be either upfront, 100,000, or a running fee that is paid. Confidentiality is really important, especially if you are about to register something or apply for something, because as soon as your patent becomes public to like 2 persons, you can't apply anymore, because it needs to be something that's unique and hasn't been on the market before. There's a classic thing that you should, if you have an idea, write it down on a paper, put it in an envelope, seal it, and write your own address on the front, mail it, and let it come back to you, and then it's stamped with a date. So, and you just leave it there. So then you have proof that I found out this. I find this ID on 30th of May, and I can prove it. So it's pretty cool. Pretty simple, Gray.
That's a great life hack.
Life hack from the lawyer.
I have a question. Law works differently in different countries. Does that work everywhere or just in Sweden?
I only know that it works in Sweden, and then also you have the burden of proof. So if someone comes, it's pretty easy to falsify. So
Do you guys write it?
no,
So it's just like
yeah, it's like a story, but it would work, I think. I mean, if you seal it enough and you get that stamp.
I have a question regarding contracts. Many of us work with offshore developers.
Mhm.
All of a sudden you're in India without knowing, or your
Mhm.
product is in India and your database is on the way to India. How can we like write contracts with third-party countries? Like, you know what I mean, developers sitting in
Right. No,
other countries.
the question was how do we write contracts with foreign people?
Can we, I mean, in our position?
Swedish law shall apply to this contract. Done. Hire a Swedish lawyer. No, but that's how you do it, basically. And then they say, no, we're performing this in India. It should be Indian law applicable. And then you put your two lawyers and they get to fight. And literally, no, but that's how you do it. So you and you can work without the contract. I mean, I wouldn't recommend it, but as long as everything is fine, then you can work without a contract. I mean, a contract is like a marriage. When everything goes along, then you don't need anything. I mean, anything written. Then you're about to divorce and start fighting over that ugly share or anything. It's good to have something written. I have nothing like that with my wife. She gets everything. Okay. Trade secrets are regulated by law, and this is everything that can be seen as unique within the company, and it's it's vaguely defined, but still a trade. I mean, I couldn't let you into this computer. That would be really bad by me. Also for you probably, because you would see a lot of secrets and stuff. And I mean, working as a startup, you probably have a lot of trade secrets, new projects, things going on that you don't want anyone to let out. So put that in your employment contracts that I'm sure you have, all of you, about confidentiality. Everything that's going on here stays confidential unless it's publicly known or you get our permission to tell the world. And the main rule is that the ownership rests with the creator of the invention or the copyright. And this could be the founders, it could be an employee, it could also be a consultant. So think about that when you bring consultants in, because when they leave, they say, well, I'll take this project with me. No, you're not allowed. That's our thing. No, it's mine. Could actually be also, if you take it to the extreme, the users, the customers. I mean, many websites today are user created because we are the ones that put all the information in there, such as Facebook and Instagram and all that. So, I mean, the picture you post on Instagram is not yours anymore. It's Instagram's, and they can do whatever they want. That's in the terms and conditions that no one of us ever reads. Not lawyers. No one does that. But and that's also a tip. I mean, more from a private kind of view. When you sign up for the different services in App Store, it says it's free, and then it's like purchase inside app, and you sign up and put your credit card details in, and after 7 days, you have suddenly signed up for a year's subscription of 129 kronor a month, and you don't want that. And it's pretty hard to fight against something that you have approved by ticking that box. So what should you do? You should transfer the ownership to your company, as I said. Put it in a written contract. Intellectual property assignments, that's a certain type of agreement where the employee or the consultants assigns everything that she or he does as long as they're in the company. You can also have that in employment contracts. Same thing there. Everything shall be assigned to the company, and the consultants agreements or the terms of use when it comes to these services that going back to that Instagram example, they have that in the terms of use. So my 350 pictures of my family are now owned by Instagram. Sad, but true. So some things to consider here in relation to the transfer of IP. Copyright, the principle of specification, that's what I talked about before. It needs to be specific and something that's not out there already. Moral rights are interesting because you cannot transfer a moral right. A moral right is the name of the photographer who took the photo. You cannot sell that. You cannot transfer it. It needs to follow the photography. So you can't like kick that name out and say that, oh, I did this. On the other hand, you can take a photo of that photograph and say, Johan Ragnar, but you can't sell it. You can only keep for your own purposes. So I have that, for example, in my room up here. There's an NFT artwork which was sold for $60 million some year ago, called The First 5,000 Days. It's the person who have taken pictures of 5,000 days. So I downloaded that from some picture site. Then I emailed that picture to one of those canvas print companies, and they made a copy for me. That's allowed because it's for my own personal use. But I cannot sell it even on Blocket because that would be illegal. Then I have infringed the artist's moral right. This goes also for falsified furniture. There were a lot of companies a couple of years ago that did Ames chair and the white chair, and I mean all kinds of Danish design, mostly Danish, and they sold that for like a fourth of the price. That's all right as long for the consumer, but not for the company because they took it to an industrial scale. Then their defense was, we're doing this from England and we don't have 75 years of protection. There's only 25. And all these are expired, so we're allowed to sell. However, the court said, you're aimed at Sweden. Sure, you're doing it from England, but you're aimed at Sweden. Swedish customers, you're shipping basically only to Sweden. And the founder was put in jail. He was also the founder of Ink Club. I'm sure you've heard about that. You order, that's okay. I mean, the Ink Club thing. But then his next venture was this furniture thing. So he got put in jail. I don't know for how long. So we have some differences here. A company name and a domain name. What's the difference? The AB is limited to Sweden. In Denmark, you have the AS, Aktieselskab. Here is Aktiebolag, of course, and that's to designate a legal entity. And you must use AB in all official publications about your company in order for people to know that this is an Aktiebolag. The reason for that is that the owners are not responsible for the debt of the company. I'm sure you're familiar with this. If you have an enskild firma, then you and the company are sort of stick together, married. And if you get a lot of debt, you can be put into personal bankruptcy. So our recommendation is to always have an aktiebolag. And nowadays, it's only 25,000 kroner in order to register a company. Then you need some legal costs and some registration fee from Bolagsverket. But still, it will protect you as a person. The .com, no legal protection. That's just an address. However, if you have registered mcdonalds.se, then McDonald's can file at a certain domain court, so to say, and claim that they have the right to mcdonalds.se. But McDonald's would have to pay some compensation to you in order to get that back. So there are people who have put that in system. I heard of a friend's friend who had registered Holland.com, because Holland is not all nations' name are protected. You can't really register them. But Holland is not a nation, it's the Netherlands. So he was smart enough to register Holland and was paid, I don't know, 500,000 or so in order for Netherlands to get that. It was pretty smart. Yes? It could. I'm not certain actually. Nowadays, when the internet was the Wild West, probably not. But nowadays they've straightened that up. So that's it. And also we have a lot of different something now. It used to be like com, se, or ny. Those were like the three most common. Now we have like synch.law, for example. We switched to that about a year ago. So I'm not certain, tell you the truth. Trademark registration. It must be able to function as a trademark. So identifiable, recognizable, people know that this is your trademark. Must not be identical or confusingly similar to earlier rights. McDonald's with a Z wouldn't be allowed. Then we have some companies that do this anyways because they want publication or they want to be recognized, famous. It's funny when you are abroad, especially in Eastern countries, Thailand and Malaysia and such. You can see many funny examples. So, and it must not infringe famous or known trademarks, of course. There are three different systems. We have the national registry, Patent- och registreringsverket. Then we have EU registration and the international registration. And both of these, please note, are not, it doesn't mean, if I apply for EU, you're protected within the whole EU. You need to designate the different countries where you want it to be protected. So, there's no point in protecting your brand in France if you don't have any intention to go to France, but you do in Germany, so there you register it instead. And the same goes for the international registration. Woohoo! Personal data, the moment you've all been waiting for. Or to put it in other words, because this is the nickname, GDPR. However, GDPR is just one regulation about personal data, but can you help us with GDPR? That's what you say. But however, being boring and all, data is the currency of today's digital economy. We have the IPR and we have the data. I mean, the new oil, the gold. Some companies, they seem to have a purpose, but the real purpose is to collect as much data as possible to sell it or use it in another way. Then how do you do that? So this is the consumer's perspective. 82% of them said that prior to GDPR, they plan to take advantage of their new rights to see the data, limit it, or erase it. Now, that means that 4 of you goes with this. So, who has acted in accordance with this? Yeah. How many pages? Collection from Instagram.
I didn't go through all of them, but it was 25 gigabytes.
25 gigabytes. That's quite a lot of data.
Yeah. And it was like all my interests. I just wanted to see like what they thought my interests were, and it was pretty like good. I could see like way back in 2013 when I was younger. I looked at a lot of Beyblade, and Beyblade was there.
That's amazing. Yes. So
Imagine if you are just one person and you had it, oh my god, 25 gigabytes.
I don't remember like exactly about it. It was something like around that.
and how many users are there on Instagram? I mean, millions and millions. So no wonder they're building these huge data centers up in Luleå in order to keep all that data. For me personally, I didn't care. I didn't use to care. I mean, so what? Just grab it. I don't care. What are you going to do about it? But now I actually put a no on all cookies. I unsubscribe from all email newsletters because I don't read them anyway. So why should they be able to collect my data and so on? However, these phones, they don't listen. I must stress that on a side note. But if Ali and I are talking about, maybe you're talking about, I'm going to France this summer. Oh, France is wonderful. And then I go back, I look at my phone and I have like 10 articles about France. Oh, so they are listening. No, but the phones are communicating by just lying next to each other. And you have probably Googled a lot about France. You have some text messages from friends saying, "Oh, it's going to be so much fun when we go to France," and so on. And then that information is transferred to my phone, and that's why I get all these things. It's really weird. They own us.
But sometimes it's not even possible to choose if you want these or not. But some websites make it really hard for you.
Exactly.
To go with this if you don't click on.
It's more like some sites are not compliant.
Mm.
Straight up and down not compliant. You should have free choice.
Yeah, no.
And some doesn't give it that.
Mm.
I think the only website where I can choose is håller. And it's not in the way of you to be on the website.
Mhm.
Most often it comes straight up on the website and you can do anything
Mm.
before you click on it.
Yeah. And also this making it difficult for you. It goes with most things, I think. I was about to terminate a subscription. I had missed that it was 1 month for free, and I missed the date. So now it wasn't 12 months, but it was another month, and I didn't want the services. It was like, took me, I don't know, 2 hours to find the right spot in order to terminate this subscription. And I couldn't do it by my phone. You can only do it on a laptop, and then you need to go to the right page. That was unavailable at the moment, Okay, now we're off topic here. But so what is personal data? Your name, obviously, your address, where you live. That's identifiable to a certain person. Where you are could also be personal data. If this has platstjänster on. It knows that I'm here at Hedge. An online identifier such as BankID, or you log into something. My health, I mean, that's very sensitive information. I don't want anyone to know about my diseases or my doctor's appointment or even when I took out a tooth. I mean, that's my business, no one else. My income, especially in Sweden, that's hugely sensitive. And you know, Ratsit, speaking about sensitive, what they have done is that they are applying, what's it called? The right of expression. So what it's in our grundlag. So what you do on Ratsit is that you enter a certain name. You want to know their income, your neighbor or whoever, your colleagues. Then you get a whole page of data. Everyone from like RA to RE. And then somewhere on that list is the person I was looking for. So you don't get one name, you get the whole page. And that's from a catalog, which is issued on the grounds of the freedom to publish. That's how they circumvent that.
But is that like the difference from Sweden and different countries, that everything is open for everybody? If you Google my name, you will see where I live, the income in that area, and you can get out all. And if I've ever been in jail or got some issues with police, you can get out everything about my whole life just by Googling my name.
That's very Swedish thing, because we have a lot of public registers. Everything is supposed to be publicly available unless the opposite.
But I believe you can, as one group, and not that. There is a way that you can extract the data. You have to request that on their site for a specific form.
We also have within the GDPR the right to be forgotten. So if anyone stores data about you, you always have the right to delete that. So for your 24 gigabytes on Instagram, you can say, well, please delete this because I don't want you to have this data anymore. So that's not... Yes, we all do, even though it sucks. And it's really boring nowadays. So the GDPR replaced old rules. There were rules prior to GDPR. In Sweden, we had personuppgiftslagen, or PUL. But since 25th of May in 2018, the GDPR applies. And this is a regulation. It means that you can't avoid it as a nation or a member of EU. It's directly applicable in each member state. So that's why we don't have an extensive law anymore treating personal data, because it should look the exact same in all of Europe. And the objectives here are to give the citizens back control of our data. Also make it simpler for businesses. Well, that could be discussed because you need to spend a lot of time and lawyer fees in order to get it right. Also to keep up with the technical development. I mean, in 1995, the digital landscape was a bit different than in 2018, considering social media and the speed that data travels all over the world. So, some keywords. We have personal data, which is any information relating to an identified or identifiable natural person. We had that man in the beginning as an example. Processing is basically anything you do with that personal data. I am the data subject, or you. The controller is the entity that controls the personal data. The processor is the one that processes personal data on behalf of the controller. And we are coming to the agreement relations on the next slide. Subprocessor is even further down, acting on behalf of the processor. So between the data subject and the data controller, you have the privacy policy. That's, you've probably been in touch with that. And then you have the data controller. That could be the online merchant, say CDON or Zalando or anyone else that collects the data. Perhaps they are based on AWS cloud. Then they have a data processing agreement between them. And then the data center in the end is acting as the sub-processor. And for all of these, privacy policy, DPA, sub-DPA, that's what we can read with machine learning and AI technology. The privacy policy used to be for free in order to create a buzz around it, and I think it was used in over 100 countries before we moved it to Mygon. The DPA can actually attaches as a Word file. You send it to an email address and it bounces back, and then you have a markup instead of a lawyer putting 5 or 6 hours into reviewing it. Quite cool. Now, the risks here under GDPR is administrative fines that could be quite hefty because they're based on your turnover. You can have an audit from Integritetsskyddsmyndigheten, as they are called now. They used to be called Dataskyddsmyndigheten. And of course, negative publicity and badwill if the press finds out that you are treating personal data in a wrong way or a way that is that damages the data subjects. This could really injure your company, and no one just wants to use your services or buy your products anymore. Say you are selling a device, a keychain, and it turns out that there's a little microphone there recording everything that you say. Probably exists. Or say the AirTag, the Apple AirTag. I mean, that's based on finding things. But of course, it also registers where are you right now in combination with your cell phone shooting out 5G all the time. Okay, just the last subject here before we end, incentive programs. We have warrant programs, employee stock option plans, and qualified employee stock option plans. All these are tools for rewarding people in your company, except for salary. It's a substitute for salary, basically. That's because in the beginning, you don't have that much liquidity. You're not able to pay a lot of money. So you get perhaps 15,000 a month in order to cover your house costs and some food. But everyone believes in the company's future. So the stock options create a tool that these options are not worth much right now, and the company's valuation is quite low. But in the future, it will be worth a lot more. So the hope kind of keeps the employees within the company. So here is a small comparison. Warrants are valued at fair market value, meaning they should be valued in accordance with what they really are worth. Employee stock options, both qualified and the others, is no consideration. You get them for free. On warrants, you pay capital gain tax. On employee stock options, you pay income tax and social security contributions, meaning the same kind of tax that you pay for your salary. And qualified employee stock options is a capital gain tax as well. So when you sell them or the shares, you pay 20 to 30% kapitalvinstskatt. And if you have income tax and above certain levels, I mean, it's up to 56% tax. Warrants are securities, värdepapper, so they can be freely traded to anyone. And the other two are formed through an agreement between you and the company. However, they are not freely transferable, so you need to just keep them unless the company or the other founders say that it's all right to sell them to someone else. Now, qualified employee options are relevant for startups because these have been created in order to stimulate innovation and digital companies, tech companies, and so on. They recently changed these rules, so they're even more generous than before. I think it was up to 30 or 40 employees before. Now it can be up to 150, so a fairly large company. The yearly turnover cannot be more than 280 million. And can't be more than 10 years old, and also you cannot be subject to company reorganization, meaning that you're in financial trouble. So the value of the holder's option cannot be worth more than 3 million kronor. And more importantly, you must work with the company for a minimum of 30 hours a week. So you can't be like part employed with 5 hours a week and have these kind of options. That's it. So if you, I hope you are satisfied with this little session and that you have learned a lot. I'll be happy to answer any questions afterwards, or otherwise I'm up on floor 1. So just prep me anytime and I'll be happy to answer. And we are not one of those lawyers who put the clock on as soon as you start talking to us. Hence, talk to a lawyer for free. Thank you very much. Strömmas i varje fall.